MT Channel Business Services.
Welcome, dear followers, to MT Channel. So glad to have you here. Before we jump in, if you get value from what we do, go ahead and hit that subscribe button. Ring the bell so you never miss an update, and of course, like and share this with your friends. Alright, today we're tackling a really important slice of the Saudi labor law, specifically Articles 119 through 141. This is where the law really spells out the rights and responsibilities that keep workplaces safe and fair for everyone, covering everything from part-time work to what happens if an injury occurs on the job.
So here's our game plan. First, we're going to nail down what the law considers part-time work. Then, we'll get into the nitty-gritty of everyday workplace safety. After that, we'll look at the special rules for more dangerous jobs, and we'll wrap up by exploring the rights and responsibilities that kick in when someone gets hurt. Ready? Let's dive in.
Okay, first things first, let's talk about status. The law has to be super clear about who's considered a part-time worker because, that definition is tied to all sorts of rights and benefits. And interestingly, this part of the law also has a really key protection for full-time employees.
And here it is, a really important point from Article 119. Let's say a company is going through a bit of a rough patch and needs to cut everyone's hours for a little while. Well, the law makes it clear. Those full-time workers do not suddenly become part-time. This is a huge protection, really, because it preserves their status and all the benefits that come with it, even when things are tough for the business. Now, Article 120 gives the minister the authority to lay out the specific rules for part-time work. But, and this is a big but, it establishes one core principle that is totally non-negotiable. When it comes to health and safety on the job, part-time employees have the exact same protections as full-time employees. No gray area there, safety is for everyone. And that idea of universal safety is actually the perfect bridge to our next section. Here, we're going to talk about the foundational rules that create a safe work environment for every single person, every single day.
At its core, the law sees workplace safety as a partnership, a real shared responsibility. You've got the employer's role, which is to create that safe environment and provide the right gear and training, and then you have the worker's role, which is to actually use that gear properly and follow all the safety rules. It's a two-way street, and it only works when both sides are doing their part.
And you can see just how seriously the law takes the employer's side of the bargain. We're talking about really fundamental duties laid out in Articles 121, 122, and 125. This isn't just about avoiding major catastrophes. It's the basics. Things like keeping the place clean and well lit, having drinking water, making sure fire exits are never blocked, and posting safety instructions in languages that all the workers can actually read. This quote from Article 123 really drives home just how proactive an employer has to be. They can't just sit back and wait for something to go wrong. They are legally required to tell a worker about the risks of their job before they even start. And they have to provide all the necessary personal protective equipment, PPE, and train them on how to use it, all at no cost to the employee.
But remember, it's a partnership. So, Article 124 outlines the worker's obligations. It's not enough for the gear to just be there. The worker has a legal duty to use it, take care of it, follow the safety rules, and maybe most importantly, not do anything that could put themselves or their coworkers in danger.
Okay, so we've covered everyday safety. But what about workplaces that are just, more dangerous by nature? For those, the law has a whole other layer of rules for what it calls high-risk environments. So, what does the law even mean by a high-risk establishment? Well, Article 128 defines it for us. It's basically any place that works with hazardous materials in large enough quantities to be a serious potential threat. We're not talking about the cleaning supplies under the sink here. Think factories or plants where a spill or a fire could be a really big deal.
And to really understand these rules, you gotta know the terminology. The same article breaks it down. A hazardous substance is anything that's dangerous because of what it is, chemically, physically, you name it. And a major incident is exactly what it sounds like, a sudden, big event like a huge leak or an explosion that creates a serious, immediate danger.
Right, so because the potential for disaster is so much greater in these places, Articles 131 and 131 bis, and by the way, bis is just a legal term for adding a second related article, they give the minister the power to issue super specific regulations. The whole point of these extra rules is to prevent those major accidents, protect the public living nearby, and make the rights and duties of workers in these jobs crystal clear. But look, even with all the best rules and precautions in the world, accidents can still happen. So our final section is all about what happens next. It's the playbook for what to do when a worker gets injured or sick because of their job.
Okay, hold on. Before we get into the details, Article 132 makes a really important distinction. The rules we're about to discuss do not apply to companies that are already covered by the Social Insurance Law's Occupational Hazards branch. If your company is under that program, a different set of rules applies. It is absolutely crucial to know which system covers your workplace.
Now, for the workplaces that are covered by these articles, the employer's duty after an injury is immediate and total. Article 133 couldn't be clearer. The employer must provide treatment and pay for all the necessary expenses. And they mean everything: hospital stays, doctor's exams, lab tests, x-rays, even things like prosthetic devices, and the cost of getting to and from medical appointments.
So the medical side is covered, but that brings up the next obvious question, right? What happens to a worker's income when they're hurt and can't work? Well, the law has a very specific answer for that too.
This table breaks down the compensation structure perfectly. So if a worker has a temporary disability, Article 137 says they get their full 100% wage for the first 60 days. After that, it drops to 75% of their wage for as long as they need treatment. Now, for the most tragic cases, we're talking permanent total disability or death, Article 138 says the compensation is a payment equal to 3 full years of the worker's wages.
And to make sure there's a basic safety net, Article 138 also sets a floor for that compensation. The amount for permanent disability or death can't be less than 54,000 Saudi riyals.
Now, it's really important to know that while these protections are incredibly strong, they do have limits. Article 139 lays out 3 specific situations where the employer is not required to pay compensation. First, if the worker hurt themselves on purpose. Second, if the injury happened because of the worker's own intentional misconduct. And third, if the worker refused to see a doctor or get treatment without a good reason.
So when you put it all together, these laws create a really solid framework for safety and care in the workplace. It's all about that balance of responsibility, designed to stop accidents before they happen and provide real support when they do. And that really leaves us with one final question to think about. How do you see these rights and responsibilities playing out in your own workplace every day? Thank you so much for watching this explainer here on MT Channel. We really hope this breakdown was useful for you. And please, don't forget to subscribe to the channel, activate that bell, give this explainer a like, and share it with anyone else you think could use it. We'll see you in the next one.